According to recent legal analysis from Fox News' top legal analyst, Donald Trump's desperate attempt to fire a member of the Federal Reserve is likely to crash and burn thanks to the incompetence of a key Trump administration official, humiliating Trump in the process, and we have to talk about it. But before we do, if you end up liking this video and you want to support the channel, please be sure to hit the like, subscribe, and alert bells before you go. All right, friends, Andy McCarthy is a conservative lawyer. He is one of Fox News' most senior legal analysts. He's legendarily respected on that network. And listen, as a contributor to the National Review, which is even more right-wing than the Wall Street Journal, Andy McCarthy is generally more pro-Trump than not, but he is willing to publicly criticize Trump more than most people in that space. And so this is what he wrote in the National Review. This is legal analysis. New developments in Trump's attempt to fire a Fed board member. It's likely that Lisa Cook will prevail in the short term for three reasons. There's a good deal of confusing analysis regarding developments in Donald Trump's efforts to fire Federal Reserve Governor Lisa Cook. The issue is pressing because the Federal Open Markets Committee is scheduled to meet on Tuesday and Wednesday of this week, aka at the time of recording, tomorrow and Wednesday. The FOMC is the Fed's main monetary policy-making body. There's anticipation about this week's meeting because the president has been pressuring for a rate cut. A cut probably of 250 basis points is expected, despite some disturbing inflation news last week, and because Cook is a Biden-appointed voting member whom Trump is hoping to block from participation in the meeting. Cook has sued to retain her position. She won the first round before Judge Gia Cobb, a Biden appointee to the Federal District Court in Washington, D.C., and the Justice Department has appealed to the D.C. Circuit. With that as a background, let's try to unwind what's happening. As I previously outlined, Trump has sought to remove the heads of various independent administration agencies, independent in the sense that they are not part of the executive branch, even though they exercise some executive power, based on his inherent power under the Article 2 of the Constitution. With respect to Cook, however, he's also cited the Fed statute under which a board member may only be removed for cause. Unlike the statutes that control other independent agencies, which define cause to mean malfeasance or misfeasance in office, the Fed statute does not define cause. In the Fed's century of existence, no president has ever tried to remove a Fed board member, so there is no controlling precedent. Trump seeks to remove Cook for an alleged cause that is unrelated to her performance in office, and this is a key part. Specifically, he is relying on claims by Bill Pulte, the loyalist that he installed as head of the Federal Housing Finance Agency, that Cook committed bank fraud, a serious federal felony punishable by up to 30 years imprisonment. Pulte's principal function at FHFA appears, this is why he's funny, and this is true. He goes, Pulte's principal function at the FHFA appears to be to peruse the mortgage records of Trump's political foes in search of irregularities, which he publicly announces as likely criminal fraud and refers to the Justice Department for prosecution. This is key, okay? Prior to referring Cook, Pulte referred Senator Adam Schiff, Trump's impeachment and Russiagate nemesis, and New York Attorney General Letitia James, who sought to bankrupt Trump and destroy his family business with a massive civil fraud lawsuit. Notwithstanding the Trump Justice Department's habitual haste to please the boss and fuel administration political narratives, no one referred to by Pulte has been charged with a crime to date. I've explained why I don't think there's a basis to indict Senator Schiff. In part, that is because establishing the crime of bank fraud is not as simple as showing inconsistencies in mortgage documents. Pulte is focused on his target's alleged claims of multiple homes as their primary or principal residences. As a matter of law, a person can have only one primary residence. A person could be motivated to misrepresent a second home or an investment or vacation property as a primary residence to obtain a lower mortgage interest rate and various tax advantages. On the other hand, the apparent claim of two different properties as primary residencies could be an innocent mistake, or there could be additional facts that show the person was not intentionally trying to defraud the bank. No one knows this better than Donald Trump. In James's civil fraud lawsuit, the state proved, for example, that he had grossly exaggerated the size of his Manhattan luxury apartment, claiming it was 30,000 square feet and valued at approximately $327 million, when it was less than 11,000 square feet and worth far less. But one, the evidence also showed that Trump had advised his counterparts to do their own due diligence. Number two, there was no convincing proof that his misstatement duped his counterparties, including banks, into doing business with him or giving him better terms. And number three, prosecutors declined to bring criminal charges. The Wall Street Journal's chief economics correspondent, Nick Taramoreos, reports that Pulte's own father and stepmother claimed tax exemptions on primary residences in two different states. Michigan has revoked the exemption, but there's no indication at this point that a tax fraud prosecution is in the offing. Schiff's mortgage counterparties knew he was then a House member who maintained homes in California and Washington, D.C. Neither residence was for vacation or investment. I've opined that the statute of limitations has lapsed on any criminal case arising out of Schiff's mortgages, but Polte's disclosures by themselves do not establish that any alleged misstatements caused material harm. In any event, Polte's allegations against Cook have been weakened in the last few days. In 2021, the reason I'm laughing is because, obviously you don't know how this is going to end up in court, but this guy, Bill Polte, we did a couple of videos about him. He is an asshole of the highest, most absurd proportions. He's a no-namer, except he's like really popular on Twitter and was appointed, again, as even Andy McCarthy concedes, is just to like scour mortgage records to try to, criminally prosecute or criminally inconvenience Donald Trump's political foes. And I saw him on a CNBC interview, and he was just a prick, even to CNBC's MAGA News host, Joe Kernan. Even Joe Kernan's like, bro, relax. I also like Trump. Take it down a bit. So anyway, this is just funny with McCarthy going through all the ways in which Polte screwed up. So in 2021, the year before she was appointed to the Fed, Cook purchased homes in Michigan and a few weeks later in Atlanta. Polte says her mortgage documents represented both homes as her primary residence. Perhaps so, but it now appears when Cook applied for the loan on the Atlanta property, she disclosed to her credit union that it would be a vacation home, not her primary residence. Moreover, when she was nominated for the Fed and subject to the confirmation process, she similarly explained to the government that the Atlanta property was a second home, again, not her primary residence. Polte has tried to put the best spin on the news, arguing that the newly disclosed information just underscores that Cook knew the Atlanta home was not her primary residence, and therefore, by his lights, the description of it as her primary residence in other mortgage documents is all the more damning. That's one way of looking at it. Yet it might be at least as likely that she made an error but wasn't trying to defraud anyone, or that even if she wasn't as transparent as she should have been, any irregularity does not rise to the level of criminal conduct or misconduct. That said, the talk about criminal fraud misses the point. The New York Times report on the matter quoted Georgetown law professor Adam Litvin as explaining that the new revelation should make it, quote, case closed on the Cook mortgage issue because, quote, there is no way to maintain a criminal prosecution. Maybe. But as the professor and the Times reporters must know, it is not necessary to establish criminal liability in order to demonstrate that a person is unfit for office. The Fed statute says that the president has to have some cause. Cause is not synonymous with criminal misconduct. Some 14 paragraphs into their report, the Times reporters concede that the new revelations do not establish that Cook did nothing wrong or was sufficiently transparent. Rather, the uncovered documents, quote, suggest she may have told her lender about her plans at least once. That would give a prosecutor pause. It wouldn't mean Cook is clean as a whistle. There is no doubt, though, that the new information improves Cook's position. That is why Cook's attorneys rushed to make it known to the D.C. Circuit after it appeared in the press. Aside, the fact that it first appeared in the press via the Reuters report rather than a proffer to the court from Cook and her counsel is a two-edged sword. Number one, it shows that the Trump administration did not give Cook a process in which she could gather evidence in her defense before Trump tried to remove her. Number two, but it also implies that upon being confronted with apparent misrepresentations on mortgage documents, Cook may have thought she'd been caught and didn't realize there might be some exculpatory information. The aforementioned Judge Cobb has already ruled in Cook's favor before the new revelations. Obviously, then, the revelations can only help. Yet I wouldn't pop the champagne just yet. In my view, Cobb's lengthy opinion is not persuasive on the central question, to wit, what does cause mean? With no definition on the statute, Cobb tried to fill the void with one, legislative history. Congress wanted the Fed's role in steering monetary policy to be insulated from political pressure. And number two, analogies, quote, for cause provision in other statutes. From this, she concluded that the only cause justifying removal would be incompetence or misconduct committed while in office. In other words, during and in connection with Cook's work on the Fed, not alleged personal misconduct prior to joining the Fed. Maybe that's where the higher courts will come out, and few doubt that this case is headed for the Supreme Court. But the justices frown on the judicial razzmatazz of mining legislative history to insert important provisions that Congress has not included, quite often intentionally, in statutory text. Perhaps Congress, or at least some members of Congress, did not want a limiting definition of cause in the Fed statute because lawmakers believed, given the unique history and structure of the Fed, that the president should have more leeway in removing Fed board members than other administrative agency heads. I doubt that, but it's a blank slate, so we're all engaged to surmise. With the FOMC meeting just 2 days away, the D.C. Circuit Court directed the Justice Department to respond to Cook's submission by Sunday, today, which was yesterday at the time of recording. The immediate question is whether Cook should be permitted to continue in her Fed board position while the litigation moves forward. I think it's likely Cook will prevail in the short term for three reasons. First, Let's assume for argument's sake that 1, a president has broad discretion to remove a board member for cause, and number 2, he may do so based on private conduct that goes to character and fitness rather than malperformance in office. And number 3, the decision is the president's. No judgment of criminal conviction or civil liability is necessary. Still, the congressional mandate of cause implies that there must be some process that establishes some objective rationale for removal. If the president could just remove at will, then the statute's cause requirement would be nullified. Number 2, by his own account, Trump relied entirely on Pulte's information to rationalize firing Cook. It now appears that Pulte's information is either wrong or materially incomplete. Even conceding that a president's discretion may be broad, it is an abuse of discretion to decide a significant matter based on flawed information. Finally, there's Humphrey's executor v. United States, the 1935 case that upheld Congress's power to restrict the president's authority to remove agency heads who wield some executive power. We noted again last week that Humphreys is in its death throes, but in May, the Supreme Court signaled that even if it overrides Humphreys, it will insulate the Fed from such a decision because of the Fed's unique history and structure, and unsaid but looming, because of the possibility that markets will crater if Fed independence from politics is lost. In other words, not an originalist prism of judicial interpretation, but a prudential one, because they just really don't want to cause any sort of practical consequence that they don't like, so they're gerrymandering the decision. I'm thus convinced that a majority of justices have already come to the conclusion that the president should have less power to remove Fed board members than other heads of administration agencies. It's not a reach, then, to deduce that if the court's going to limit the president's firing authority, then the justices will reject the notion that Trump can remove Cook based on allegations that have not been proved, relying on information that might be wrong, involving conduct that had nothing to do with Cook's official duties. In other words, this has been, at least so far, a spectacular embarrassment for Donald Trump, mostly because of Bill Pulte. So I think it's hilarious that even this top Fox News legal analyst, who really wants all things being equal to give Trump the win, to give Republicans the win, to give conservatives the win, is saying Pulte really screwed this up, and Trump screwed this up by relying so much on Pulte, and now he's kneecapped his own position to try to fire for cynical purposes, if not nefarious purposes, to take more direct control of the Fed, and now the whole thing is likely to crash and burn. Obviously, it's possible that that doesn't happen, but Andy McCarthy is not somebody who goes out of his way to opine against Trump unless he genuinely believes Trump is screwed, and so I think this is definitely worth looking into. In the meantime, let me know what you think in the comments.